right, we're going to go ahead and get started so we can be on time. I know we have several bills on the calendar. I have a hard stop at 4:45. Hopefully we can try to get through these bills as much as we can. Before we start, can I ask Vice Chair Reeves to give us a quick prayer?
Let us pray. Dear Lord, we thank you for this day. Pray that you will bless us with wisdom, justice, and moderation. In your name we pray. Amen.
And before we start, wanted to recognize a judge from Mountain Circuit, Chan Caudell. Judge Caudell, thank you for being here. Thank you. Okay, we are going to start with Vice Chair Lisa Hagan's bill, House Bill 909. Thank you, Representative. I know you stayed last Friday, the whole meeting, but so we're happy you're back. And you may proceed when you're ready.
All right. Thank you, Madam Chair, members of the committee. We are working from our second sub to House Bill 909, and that LC number that I believe is the one we're working from is LC 481112S.
Okay, I think we all have that in our folders. Yes.
Okay. Well, this bill, we just have kind of dubbed it the First Offender Modernization Bill. As you all know, this First Offender Act was enacted in 1968 so that Georgians, people who, due to perhaps poor decision making, other reasons, find themselves in a situation where they have made a mistake and they are offered a second chance frequently by using the First Offender Act. And what we're doing with this bill is not seeking to change its intent at all, but to modernize it so that in a day when we are dealing with everything being on the internet, that if someone has been sentenced to probation, that they truly do have a second chance at the end of their completion of their sentence, but by sealing their court documents at sentencing instead of at the completion of their sentence. And I've been asked several times why I was excited to carry this bill, and I think I can sum it up by a little short story that one of my sheriffs told me last week when I called him about this. He said when he was early on in his law enforcement career, he was pulled aside by a more seasoned law enforcement officer that shared with him this. He said, you know, the difference between us and the people behind the walls is that they got caught. And he said it always stuck with him, that people make mistakes, and we don't want that to hinder their progress, hinder them from being able to move forward with their life, finding a job, finding a place to live for themselves and their family. And so I just think that the intent of the bill is honorable, and we want to maintain it. We want to make sure that people truly do have that second chance that they're promised with our first offender law. So I'm sitting here with Wade Askew from Georgia Justice Project. He can talk more specifically about the inner workings of the bill. I can tell you that we were approached by the Department of Community Supervision with a concern, and so we worked up a sub for them. They are now happy with the bill. We also were approached by GBI with a concern. We do have the sub that you see here is the result of working with them. I do believe there is a sub or an amendment that Mr. Askew will address that we'd like you to consider also for GBI, but that is it. So
And we don't have that amendment. You have it.
He has that.
Okay. And just for the non-criminal lawyers on our committee, just real quick, and Wade, if you want to take this, can you just tell us real quickly what first offender does and who qualifies?
Absolutely. Thank you, Chairman Hong. Thank you, members of the committee. So I'm Wade Askey. I'm the policy director at Georgia Justice Project. So yes, I can kind of walk through what the First Offender Act is, its intent, and really on the ground how it functions. So as Representative Hagan mentioned, it's been around since 1968. So in a lot of ways, it's kind of our original second chance bill. The way it works is if I'm accused of an offense, let's say felony marijuana possession, we'll look to see, is that offense, first of all, just eligible under the First Offender Act? There's a lot of offenses that are just categorically ineligible. Your most serious types of offenses, you're not going to get a First Offender Act sentence for those. Second, we're going to look at my record. Do I have a prior felony conviction? If the answer to that is yes, First Offender Act is not available to me. It is what it sounds like. It's first offender. And then thirdly, have I used the First Offender Act before? If that answer is yes, again, categorically not eligible. This is, once again, first. So you can use it once in your life. So if I fit all those criteria, then what happens next is my attorney, prosecution, the judge might work together and we say, okay, this is appropriate for a First Offender Act plea. If I take that plea under the First Offender Act, the first key note is that this is not a conviction. That is not a criminal conviction. But instead, I'm going to be given a sentence, typically, though not always, typically it's going to be a probationary sentence where I have a number of requirements that I need to abide by. As long as I successfully serve out that sentence, then at discharge, at the end, I will be successfully discharged, which means that permanently this is not a conviction. One key here to note is that at the time of sentencing, under current law, at the time of sentencing, the court can go ahead and both restrict and seal that record. Restrict refers to limiting access to the GCIC, our official GBI record. Seal means sealing court records. Both of those, to be effective in the overall goal here, which is to say this is a non-conviction, we don't want the public to see it, we want you to be able to maintain your employment, keep steady housing, and move forward successfully. Both of those things are essential there because unless we seal a court record, as Representative Hagan was mentioning, the way background checks work nowadays here in the 21st century is they do digital searches to get hits from any local court to see if there's a record. We asked GCIC for actual data to say how many people are successful. I said if I make it successfully through, is discharged successfully. GCIC database since 2017 shows that only 2% of people on the First Offender Act get a revocation and a conviction on their case. So overwhelmingly, people are successful, which makes a lot of sense for this particular population, for this particular purpose. And so the other key that I want to highlight in relation to this bill is I said that at sentencing, we can restrict and seal, but then at discharge, current law already is we must restrict that record. And that's where some of the gap in what used to work in 1968 and what we need in 2024, where that gap is. We say you have to restrict it in the GCIC database. The results of that, where we don't seal, is that clients are all the time, individuals who are sentenced under this are told, this is going to remain private. We're restricting this record. This is not a conviction. You can move forward. However, we have people come to our office all the time who are years removed from a First Offender Act case, and all of a sudden it's popped up. And they come to us saying, what has gone on? I was told this would be private, and they're shocked. And we have to explain it was not sealed. And so, yes, this can show up publicly. So the idea for this bill actually came up with a client of ours who actually testified in front of this committee last year on a different bill, who was in that exact situation. He was a 3.98 student at Georgia State, was about to go off to grad school to become a physician's assistant, and discovered, wait a minute, I'm about to apply and my First Offender Act case is going to show up. And so we represented him on that. And we had to go through a complex procedure to be able just to do that last step in the process of sealing. So what this bill would do is kind of just make that simple fix, simple to both restrict and seal, so that's effective at sentencing. If somebody does not successfully perform on their First Offender Act sentence, such that their First Offender Act status is revoked and a conviction is imposed, then we unseal, we unrestrict for that, again, 2% of cases per the GCIC data. But for everyone else, we do what we already say that we are doing, which is we keep this private so you can be successful, so you can move forward. And like that student that we worked with, hopefully help chip away at some of our healthcare employment shortages in his case by being able to move forward. So that's the intent of this bill. And we do, as Representative Hagan, we wanted to make sure that these changes would not interrupt current operations or needs for GBI to do reporting they need to do, for DCS to do what they need to do. So that's the reason the sub is there. And then we have one line that I can distribute that GBI asked would be added just to make sure that if someone is seeking a firearm license, that the fact that they're currently serving a First Offender Act sentence while not a conviction, still important for that to pop up. And so that there's just one addition that would show up twice in this bill, lines 43 and 74, I believe, to capture that. So with that, I'm happy for any questions.
All right. Sorry, I'm just trying to. So we're going to be inserting this line 43 and 74. Okay. All right. Thank you, Mr. Askew. Any questions from the committee? I do not see any questions. We do have one person signed up to speak, so I'll go ahead and call that one. Is Jacqueline Harn?
Thank you.
Please, thank you.
Hello. Thank you all for having me back today. Chairwoman Hahn and members of the subcommittee, Americans for Prosperity works to reduce unnecessary government barriers that limit people from reaching their full potential and realizing the American dream. We support HB 909 because this policy will advance this vision. It is of the utmost importance when reforming the criminal justice system that public safety be the top consideration. Another important consideration, though, is ensuring our processes aren't unnecessarily keeping people from getting their lives back on track when they've made mistakes. The reforms to the First Offender Act within HB 909 will ensure that a person who is not a public safety threat and not convicted of any crime that will not have their prospects in life dimmed by one mistake. Thank you for your consideration. I encourage you to support this great piece of legislation. Thank you all.
Great, thank you. All right, we have no questions, and I think that was the only group signed up. So any committee discussion? Don't see any. I will entertain any motions at this time. Vice Chair Reeves?
Move do pass.
All right, we have a move to pass. Do we have a second? Second. All right. And do we have any amendments? I know Mr. Askew had given us a potential. Vice Chair Reeves?
Let me take one step back. I move do pass with insertion at lines 43 and 74. The following language is new subparagraph 4, Roman numeral 4, for the purpose of any determination regarding the transfer of a firearm or the issuance of a license pursuant to Code Section 16-11-129.
Okay, so Vice Chair Reeves has moved to pass LC 481112S with inserting the language that he stated. Is there a second to that? All right, and okay, so we will be. No, I'm sorry. Hold on. Does he motion to move with Okay. Vice Chair Reeves, we will be voting on the amendment first, and then we will vote on the entire bill. So, okay, so just as I stated, for that amendment, we have a motion and a second. All those in favor of the amendment to the House Bill 909, say aye. Those opposed, say nay. Okay, so we have the amended language passed, and then we also have a motion to pass 909 as amended. For those who are in favor, say aye. Aye. Those who oppose, say nay. Okay, your bill has passed. Thank you, Representative. And just a quick announcement. I know a lot of people have signed up for House Bill 425. It's my understanding that Representative Gullett is presenting another bill in another committee, so he may be running late. That may be the last bill that we hear, just so you guys are all waiting on. Okay, next we will take up Representative Cameron. Are you ready? All right, Representative Cameron, House Bill 590.
Good afternoon, Madam Chairman. Thank you for allowing me to come before the committee. I bring Bill HB 590 LC 365532. This bill deals with the issue of online menacing, also called doxing, where it could be confidential information or other information is released about an individual to their detriment. This bill emanated last year from the incident where at the Atlanta Police Training Center, where there was an incident, some people were hurt, one person was killed. Subsequent to that event, there was a website created called Cops of Cop City, where information on over 1,800 peace officers was put on a public website for people to look at. It could be Social Security number, it could be any kind of personal information about a spouse, children, those kind of things. So that's where this bill emanated. I'm glad to work with the Attorney General's office on this. And basically what this bill does, it defines in Section 1 what an immediate family member is, a peace officer, the information that could be released that could be considered under this bill, and the penalties, and the reasons that it could cause damage or harm to an individual, and what's going on with the penalties. So that's, in essence, the bill.
All right. Thank you, Representative. And you have somebody here with you. Would you like to speak?
Sure. Good afternoon. My name is John Fowler. I'm Deputy Attorney General with the state of Georgia. I'm over the Criminal Prosecution Division. I've had a lot of involvement in the training center case. I'm the prosecutor on the case. I just want to thank the committee for the time this morning. This website, Cops of Cop City, isn't just limited to personal identifying information. It's photographs of their children, photographs of their spouses, photographs of their partners, home addresses, and all of those things. This website is not easily taken down because it's stationed overseas, and so it can't just be taken down. It requires a significant amount of resources to even identify the person who might be running it. It has taken an enormous amount of resources to do that. And so in the meantime, all of this stood up there, and anybody who wanted to find it could find it. What's particularly concerning about a website like this is that anybody can access this information. I don't recommend anyone does, but anyone can access this information. And not just that, but the person that posts this information has no control over the people that access the information. Anyone can do anything. And the victims of these crimes have to continuously look over their shoulder if they know that it's out there. They can't stop it from being out there, and that's what makes this such a serious crime.
And also, I think the stress level of a peace officer in Georgia is enough as it is. Then to have to look over your shoulder and worry about family members, that's an extra added stress that they don't need. And it creates a situation that's kind of chilling, that if you're trying to do your job, that your family members could be harassed or even harmed. Your financial information could be released, those kind of things. And we need to stand up for our peace officers in Georgia and say enough and draw a line here and make this illegal and protect these folks.
All right, thank you, Representative. We have one question, Representative Miller.
Thank you, Madam Chair. Thank you for this bill. I just had a question about the scope of it. Was there any consideration given to allowing this proposed statute to cover other public servants besides law enforcement? So, for example, elected district attorneys or elected city council people who also received a significant number of threats. Can you just talk to us a little bit about the choice to limit it to police officers?
There was discussion, but we really wanted to start out with peace officers in the state of Georgia. You know, there's another day to broaden it. I mean, even legislators, the threats that some legislators get. But we wanted to keep the scope intentionally narrow right now to cover this situation and provide some relief in this situation. But we are, in the future, I think there probably will be more.
Follow up, Madam Chair. And then also, I just had somewhat of a technical question about the definition of immediate family member. Did this definition come from somewhere else in the code?
The definition actually came from the federal statute, is where it came from. There's a federal statute that is similar to this, and that's where it came from. The reason why it is codified under state law is because, Representative is seeking to codify it under state law, is because the federal statute only covers incidents involving federal cases. So, for example, if you had a murder case here in Fulton County or DeKalb County or somewhere like that, the federal statute wouldn't cover that. So this largely mirrors that.
So is it your belief that, let's say, the stepchild of a police officer would be covered under the statute?
I don't have the statute in front of me. May I take a look at the statute briefly? Thank you. If a child is considered a stepchild, then yes, I can't speak to whether it would be or not, but I do see that a child would be.
Mm-hmm. Okay.
Representative Roberts.
Thank you for this bill. I agree these incidences are dangerous, and it makes it hard for us to recruit folks that are willing to subject themselves enough to the job. I think that's true for a lot of the jobs that we in the public are doing. I guess my only question is, under the personal information means, are you saying that someone can't post a name, just a name, no additional personal information
So
by itself, I guess is what I'm asking.
you can post a name, yes, but that's why there's a second portion of it that has the intent prong, which is that you can post someone's name, but you also have to have the intent to do something with that. Okay. So for example, if you go up and say Officer John Smith made this arrest, not a big deal, you can do that. So if media wants to do that, they can do that.
Okay.
But there's also the criminal intent prong, which is that you have to have some criminal intent to bring a threat or suggestion of or request for physical injury, serious physical injury, or violence of any kind. So that's where that limits that overbroad concern.
And we're not trying to limit anyone's ability to free speech of saying they disagree with an officer or they use language that some of us might feel is offensive. That's their First Amendment right, and I would protect that. I would stand in front of them and protect that all day long. But when you get into a position where you're committing malice towards a peace officer, that's where we kind of draw the line.
Thank you, Madam Chair. So as you mentioned about doxing, that most of these things might be coming from overseas. My question would be, how would you implement this? Like, what would be the practicality of implementation? How could we stop this from tracking this from overseas? Like, what would be the implementation of it?
Sure. So what we have to do is we have to partner with our local, state, and federal agencies, and use every resource that we have. We have good relationships with all three of those. There are federal warrants that can be sent that the state does not have, and so we have that ability. And also not just that, but we also see it in different instances as well that are also both domestic. That could be whether it's posted in California, whether it's posted in Georgia, whether it's posted in Maine. And I don't pick those three states for any reason other than using them as examples. But there are things that we can do. It just can be difficult, and we have to use every resource that we have.
Representative Miller.
So is your belief that if a person in California or Oregon or some other state engages in this offense from Oregon or California or wherever they may be, that we would have jurisdiction as this is written to extradite that person here?
The venue lies here? Yes.
Is that in a separate subsection, or do you address venue in this statute?
No, but I do believe that, no, it's not as far as I know, but I do believe that we would have venue here because it's posted here as well.
Based on what?
Based upon not just the things such as the identity fraud statute, where it occurs, and also where the victim lies and other things like that. I believe that that's where we would pull venue from.
Okay, and so you believe that we would not have to separately have a venue provision in this statute? We would just rely on the venue provision in identity theft or someplace else in the code? I'm just literally asking because...
No, it's a very fair question because we do, and I apologize, I don't mean to interrupt you, Representative.
No, you're fine.
I do think it's a fair question because as we evolve with cyber crimes and those sorts of things, venue is always an issue. There's no doubt about that. I don't think it could hurt to add a venue provision to it. I don't. But I do think we would have venue here at the end of the day.
Thank you.
All right, thank you, Representative. Thank you. We have two groups signed up to speak, so I'll go ahead and call them up. First is Terry Norris. Hey, how are you?
Good afternoon.
Good afternoon.
I'm Terry Norris. I'm Executive Director of the Georgia Sheriff's Association. And very briefly, I'd like to thank Representative Cameron and the committee for hearing the bill. We need all the help we can get. There may be some questions about venue and those other matters and prosecution, because we do know that prosecuting folks in other countries is sometimes difficult. I think there are ways to do it. I think the attorney adequately, in my mind, expressed how that might be done. It might not be done right away, but I think it can be done. But I think you all are not here to pass legislation to send messages, but this does send a message, I think, to all of us in law enforcement. It sends a message that you are doing things that will attempt to support us. And God knows y'all have expressed that time and time again down here, and we greatly appreciate it. As I said, I work with the Georgia Sheriff's Association. Folks, these are your sheriffs, and the things you all do down here affect your sheriff. So we come down here a lot of times and we speak on a lot of issues. In fact, I'd like to address the committee on Representative Vance's bill as well, very briefly. But we're here in support of this bill, and we appreciate the support that you all give us.
Thank you.
Thank you.
Maisie Lynn. Welcome back to Judiciary this session.
Thank you. Wonderful to be here. I'll try to be quick. I'm Maisie Lynn Gerton. I'm the Executive Director at the Georgia Association of Criminal Defense Lawyers. And actually, Representative Miller mentioned something that is, whenever we see, especially a new crime brought that has a specific status victim, it is of concern to us. I will deny it to my membership if you tell them I said, why not just apply this to everyone? the idea of having to come back in over time and decide this year who is special enough to have this kind of protection seems inefficient at best, and also exclusionary at worst. And when you look at the particular definition of peace officer, I'm sure you look at this definition a lot. It varies throughout the code. The one that was selected is very broad and goes well beyond frontline, first responding police officers. So it's already a fairly broad category of people. Why not just start with every citizen in Georgia deserving this kind of protection from this kind of arguably violent behavior? Like I said, denying it.
Thank you. Representative Mogwag, did you have a question?
Question for the AG's office, actually. Just popped into my mind. I'm sorry. Do you think that this leads to a potentially crossing threshold of privacy and security policies of certain social media platform? It's just not the website, right? So people are sharing this on Instagram. Would Instagram be approached that they cannot do that, or Facebook? Nowadays, it's just not only a website, right? I mean, that information can be shared or posted from the same website to a different account. For example, it's xyz.com. They have a website, and they can go xyz.com/Facebook/Instagram/TikTok. How do we work that model if those companies can come back and say, well, you can't stop us from sharing that?
Well, I think that this bill is largely, and I don't want to speak for representative here, but I think the bill largely targets the bad actor, the individual bad actor, the person that says, I want to take this information and I want to frighten this person into no longer doing their job or no longer wearing their uniform, or even when they're not wearing their uniform and they're home watching the football game on Sunday, that they're worried about someone coming to their house. And so I think it's targeted largely at the bad actor, not at the broad whether it's a blog, whether it's Facebook, Instagram, TikTok, whatever it well may be. I don't think it's targeted at them. I think it's targeted at the individual the bad actor. And I hope I answered your question.
More privacy, which is content sharing. I have a website. It has the same account as Instagram. So I share my information everywhere. So if this bad actor has a website releasing information of a peace officer, he might be sharing that information on different platforms, Facebook, Instagram. How would you stop that? Or how would you go to Instagram and say, well, sorry, you can't do that, it's against the law? And that's what my concern is, that it's not only just one platform. They're on social media, there are multiple platforms.
So I think kind of what you're getting is sort of the auto share, if you will, without someone going in, typing, clicking, share. I think that's what you're getting. Is that fair to say?
So they can create just a website, right?
Right. I think I understand.
Just a website. They can also create a Instagram account,
right,
and share that on an Instagram account or a Facebook account. So how would you approach the website? Is understandable, but then how would you approach to, let's say that you approach to Facebook and says, well, you have to get this information out because this is a personal information and we have a law. Would this allow to reach out to those social media platforms from Instagram and Facebook? And what if they say, no, you can't do that because it's a First Amendment right?
Well, would this bill allow us to reach out to, say, Facebook, and we'll use them as just an example if that's okay with you. Would this bill allow us to reach out to them and prosecute them? No, I don't believe so. Because number one, it requires an intent prong. And the intent prong requires that you are posting this for the reason of incurring serious injury and the like that is in the bill. So no, I don't believe so. That said, if it's out there, do we reach out to them and use our law enforcement connections and say, hey, you guys have some information out there that could bring harm to an individual. Could you take it down ASAP? We absolutely do, and that is something that we absolutely do. So does it meet the criminal intent prong? I don't think so under your hypothetical, but of course we're going after the bad actor themselves.
I have a quick question. So if in fact this happens, did you consider any type of or can you utilize injunctions to make sure the information comes down? What are we doing about, hey, we've actually found this and the person? What are we doing about the information that's actually out there in order to hone it in?
Absolutely. And Madam Chairwoman, I appreciate the question because that's a really good question, which is that this bill is targeted at prosecuting bad actors. And to get this information off of the internet requires a larger attack on it, for lack of a better way of putting it. I'm a prosecutor. It's what I've done for the 13 years of my career. So in terms of an injunction, I don't do injunctions. I prosecute people who have committed crimes. So I can't speak intelligently to that. What I can say is that oftentimes we reach out to folks and let Instagram, Facebook, all of them know, hey, this needs to come down and here's our problem. And a lot of times they employ a significant number of former law enforcement who work for them that say, oh, you're right. And they look into those investigations and they can assist us with things with subpoenas, search warrants, and emergency search warrants if we need information. It's difficult from a broad perspective to speak on every hypothetical. But the reality is that the prosecution of an individual doesn't always solve the crime, but it does help solve the crime, and it does help deter it as well. And I know that wasn't a direct answer to your question of specific steps in terms of injunctions because I'm a prosecutor and I know what they are, but I don't know the steps always to take them, but I hope that helped answer your question.
And I don't know that part that well, and Representative Cameron, maybe that's something that we can look into as well to see, because obviously the intent is not only to prosecute people that are doing this, but also to get the information off and or to stop any distribution of that information. All right, Representative Roberts.
Thank you. If you're Taylor Swift, apparently they just shut down any ability to search Taylor Swift on X or Twitter. So I know if I'm assuming bad actor would also be defined as with child pornography. If you forward child pornography, you can be prosecuted for that crime as well. So if someone forwards the threat with the private information, they would also be liable under this.
Absolutely. So long as we could prove the intent prong that was the purpose of the reason that they did it was to bring serious physical harm to the individual or something like that, yes. For example, an exception may be that if one comes to my attention and I forward it over to an investigator for the purposes of investigating that would not be a crime so long as I'm not trying to bring serious physical harm to whomever is the target.
Thank you.
Okay, so that's all the questions. Thank you. Any motions from the committee? Representative Crowe?
Move to pass.
Do we have a second? All right. And any discussion? Representative Miller?
Yes, I just had a couple questions, actually. I probably I had my button pushed and then I took it off because I thought Representative Roberts was going to cover it. But so just for clarity's sake, and I'm thinking about the website that my colleague referenced from some of the Atlanta Public Training Safety Center. As I understand it, and I'm not familiar with the website, I haven't seen it, this is just my understanding, that information about law enforcement officers was posted, but without the threats. And so, and if I'm wrong about that, I'll stand corrected. So the question would be, if the specific threat is not contained in the post, does that put you in a quagmire for purposes of proving intent?
I don't think so. With the ongoing investigation, I can't speak specifically. It would be inappropriate for me to speak specifically to the website itself. What I will say is that given the overall context, this is under one subcategory of a website. And if you go to the other subcategories of the website, it places it in context, and I'll leave it at that. And so you're really getting right at the gravamen of the intent prong. And I know that you have particular experience in the criminal arena, and so you know that intent can be proven by circumstantial evidence, right? And so if you go to, in particular, websites like this, you can see why people forward this sort of stuff. You look at the other things that they post. You look at things like motive. You look at things like previous posts, later posts afterward. What's the purpose of what they're doing, and all of that sort of thing. And that can give you a glimpse into someone's mind of the reason that people do things. There's a saying that every person of sound mind and discretion intends the natural and probable consequences of their actions. I know you're familiar with it. You've heard it many times. And that's exactly what's going on here. I don't want to say here, but that's exactly what goes on in some of these things, which is that they try to do it, but it's very clear from the overall picture of what they're doing that the purpose of what they're doing is for the purposes of bringing serious physical harm or threats to the individual.
Representative Miller, we'll take one
Just
more
one
question.
follow-up on what he said, Madam Chair. Thank you. I do appreciate your indulgence. And so I guess then just in balancing what Representative Cameron said about the First Amendment and the protection of a citizen's First Amendment right to express themselves, do you anticipate that being sort of an affirmative defense to a prosecution, or do you, and it's probably a combination of things, or is this something that would be evaluated on the front end? In other words, if the threat is not contained in the post itself and you're pulling from other sources to sort of, circumstantially prove intent, how then does the First Amendment in your mind play into that?
Do I anticipate that the First Amendment may be used as an attempted defense here? Sure, absolutely. Anytime there's speech involved where there may be a crime, such as terroristic threats or anything like that, you can expect a First Amendment defense. But there's an old saying that the First Amendment ends at somebody's nose. Now, of course, that involves violence, but at the same time, implied violence is with that as well. And here, that implied violence is where it crosses over the line. Everybody needs to be safe. Everybody should be safe. Everybody's not safe. I recognize the reality of it. But that said, do I expect that? Yes. Will there be an evaluation up front? Absolutely there will be. And there are processes for that. There are preliminary hearings. There's grand jury. There is the evaluation of things, attorneys that look at it, all of that sort of stuff. And the First Amendment is an absolute defense to protected speech if it reaches the trial stage. So yes, absolutely.
All right, Vice Chair Reeves.
Thank you, Chairwoman Hong. Wanted to bring up Counterman versus Colorado, decided June 27th, 2023, so after the last session. I like this case because the U.S. Supreme Court defined the First Amendment in cases of reckless conduct with intent to cause somebody to be threatened and feel apprehension of physical harm. It pertained to social media. And I think that's something for us all to look at this session, and I think you've got a good bill.
Thank you. Okay, so we have a motion and a second to pass House Bill 590, LC 365532. Those in favor say aye. Those opposed say no. Okay, your bill passes. Thank you, Representative Cameron. Thank you. Mm-hmm. All right, Representative Vance, House Bill 922. Thank you for coming back. I know you sat with us last week as well. Thank you for being patient. And whenever you're ready.
Madam Chairman, Committee, I really appreciate this opportunity to be here on what's really my first presentation of real legislation. And so be kind, please.
Representative, can you bring the microphone a little closer to you?
How about that? I'm talking today on LC 4131S. Oh, I'm working off the original, yes, sir. Not the sub. Oh, my bad. I gave somebody the sub a while ago. Excuse me, LC 394059. We'll try that one.
Hold on one second. Let us,
It's the one in your folder.
okay. So we, no sub, just LC 394059.
Correct.
Is that correct? Okay.
No S.
All right.
What I'm trying to do with this bill, ladies and gentlemen, is tighten up a current aspect of the law in the criminal trespass code, which is 16721 in the code, by adding 3 lines, really. And those 3 lines say on section 4, enters upon the land or premises of another person or into any part of any vehicle, railroad car, aircraft, or watercraft of another person without consent of the owner or rightful occupant. Sheriffs contacted me and said the old law as it stood was not appropriate. Here's what's happening today. You go out of your house in the morning to get into your car and someone's sitting in it. You immediately go back into the house and call 911. You have not said anything to any person, to that person in your car. Law enforcement comes up. Under current law, as it now states, that is not a crime. The car door was open. They sat in there. You did not tell them to get out or do anything. So there is no point there where you said you can't be there. You ran back inside. You were apprehensive. You called 911. Under this change, this small change in this law, it would allow law enforcement to come and make an arrest for criminal trespass here in that instance, and in those other instances, homes, railroad cars, aircraft, and so forth. That's it. That's the only thing we're asking for here, is to really close up a small loophole in the current law, where if someone wanders onto your land and it's not posted, it's not anything, you have not invited them on, but they come there and they sit down on your front porch. You look out the window, you see them. You call law enforcement. You have not confronted them. Law enforcement can come and make an arrest for that if the law enforcement deems an arrest is necessary. Back in the old days, ladies and gentlemen, we had characters in our town that would just wander around. And sometimes they would wander onto your property and sit down and in the shade or wherever. Times have changed. We do not know the intent of that person anymore. We do not know what they're there for, whether they're for you, whether they're there to commit any damage. Now, if they do that, then they've crossed over into another area of the law, which an arrest can be made. But under current law, as sheriffs and police chiefs tell me, they can't arrest unless that person has received notification that they aren't wanted there, or in your car, or in your rail car, or in your boat, which we've seen, I personally have seen many times and had to deal with these people. So what would happen in the past is you'd go up and you'd say, sir, you're not, are you supposed to be here? They would say no, and you ask them to leave. That was really about all you could do, unless the owner of the property had confronted them previously. So we're just really trying to tighten up a small section of a very broad law and make it where an arrest can be made, whereas today it cannot be.
Thank you, Representative. Representative Roberts, do you have a question?
I'm really trying to think this through because, so currently under the law, notice is required before you can charge anyone. Okay. I'm thinking about it in the context of all of us around around these desks, in that when we go out and knock doors to talk to our voters, if there's a sign posted that says no trespassing, I don't go knock on their door. But if there's no sign, I can go. This law would allow them to say I didn't have their consent.
Ma'am,
the way it's written.
Okay, no, and that's a good point.
Okay.
But here's the thing. I think we've got to use a modicum of common sense here. Somebody going out, and you probably got a shirt on that says vote for me for this House of Representatives seat. You know, I think people understand that, and law enforcement understand that. We're not trying to take away officer discretion. We're not trying to do that at all. We're trying to say that in those very narrow cases, I'm not talking about what you're doing. I'm not talking about Girl Scout cookies, salespeople.
That's even better.
I'm not talking about that. But we're talking about a very narrow part of the law that right now today would make people apprehensive. I don't think someone coming to the door asking you to vote for them would make you overly apprehensive. Some people in today's world, yes, ma'am, you're probably right. But don't lose sight of officer discretion and common sense. This is in those times where you walk out that door in the morning and someone's sitting in your car. The door was open. They said, I'm going to sit. You run back in the house. You call 911. The law enforcement officers come, officers come, and deal with that person. And in that very narrow circumstance, I never want to take away from officers' discretion or people's ability to contact law enforcement when a crime may be taking place.
May I ask another question, Madam Chair? So, would this law also address the issue of squatting?
Well, ma'am, I think it would, because you got people that show up and go into houses and just set up shop, which to me is unconscionable, but to them, they think they have rights, and I call it stealing, but I think this does, in a broader sense, do that as well.
Okay.
Thank you for your question.
And I have a thought, but Vice Chair Reeves,
Ms. Representative Vance, thanks for bringing this bill. Question: if we can show some shortcomings in current Georgia law about similar criminal trespass on houses of worship, particularly in light of that Counterman versus Colorado case last June, would you consider at the full committee entertaining a sub that includes houses of worship to this criminal trespass bill, where people are coming onto houses of worship to threaten people and disrupt worship?
Representative Reeves, that's a great question, and I think under broad circumstances that may already be covered under the law. If this committee chooses to do that, that's certainly y'all's prerogative. But I think, and I had a substitute that did those kind of things, and I got to talking with lawyers and law enforcement officers, and they say, well, that's covered now under the law. If you come to a house of worship, and we have laws that cover instances of criminal intent on church property. They said, we've already got that covered, but we don't have this part covered.
Okay, I'm going to try to make this question a two-part question, right. Representative. So line 19, we have enters upon basically the same language for an unlawful purpose. And because it says for an unlawful purpose, I believe what you are stating is that unless we can show that unlawful purpose, that's where the officers are having an issue.
Correct.
And on that note, I was thinking about kind of going back to Representative Roberts, and what if it's just an innocent person that just happens? What if I got your house wrong and I was at your house, and what if my friend said go and wait on the porch, and I was waiting on somebody else's porch and they called 911? Can we possibly think about maybe adding some kind of an intent? So possibly saying, without the consent of the owner or rightful occupant, with an intent to commit a crime, and I'm just kind of thinking off the top of my head. So,
but then, Madam Chairman, you've got to prove that intent. And when you have these other situations where some damage does occur, you prove the intent by the actions thereof. They've done something on your property. Here, without intent being known, what they're there for. You've called law enforcement to come to your house because somebody's there. So I think, Madam Chairman, we've already got that in the law. But Here's my problem with a lot of laws like this. We confuse a law that was good to start with by adding on to it and added language to it. This is simply saying that if you enter upon the land or premises of another without the consent of the owner or the rightful occupant, you haven't done anything else. The intent is that you're there. You're there without any authority. You haven't done anything else. I don't know your intent if you're going to do anything else or not. The intent is that law enforcement can act. It doesn't mean they have to. That means they have the discretion of making that charge just upon that circumstance.
Right, and I understand your, again, going back to kind of reasonableness, you know, an
Correct.
officer will come, and if I was
Correct.
hanging out, it may not be for that reason. Okay, I don't think we have any more questions, but we have a few speakers, so I'll go ahead and start calling on them. On House Bill 922, Terry Norris.
Yes, Madam Chair, very quickly. We are in support of the bill. I think this came from one of Representative Vance's sheriffs. But in hearing the testimony and the questions, obviously there might be a little bit of work that needs to be done. We'd like to facilitate that discussion if it occurs. But I do want you to think about this. Giving notice is required under current law on trespass. And possibly in the example given by Representative Vance, someone in your car without saying, get out of my car, there's no notice. So possibly on the trespass code, given some verbal notice, please, you need to leave. If they don't, then possibly a call as one counter suggestion. But otherwise, there could be some exclusions added to the code or the bill, which we'd be happy to help with. As I said, this came from one of Representative Vance's sheriffs, a very active sheriff for probably close to 40 years. And I think the sheriff talked to me about this bill as well, or the problem. And it's around the lake community down there. And there was more than one incident where somebody just shows up and is sitting on one of the residents' front porches. And no reason for them to be there. The people don't know it, especially the elderly. They see someone like this. It is very troubling to these folks. So I think, as you all do all the time, you think about the victims as well. So again, we'd be happy to help with this if the committee so chooses.
Thank you. I appreciate you offering that. You have one question, actually. Representative Miller.
Thank you, Madam Chair. As this bill is written, would a police officer engaging in a knock and talk without any search warrant or probable cause or reasonable suspicion, who walks up onto the porch of a citizen?
That could be an exclusion.
I'll talk about this. But so, just that's unintended consequences,
I do get it.
right?
Yes,
So I think perhaps a little bit more thought into this, because I do think that might actually make a law enforcement officer engaging in lawful activities, a felon.
Absolutely. We'd like to help with that. Thank you for the question.
Thank you. Maisie Lynn.
So I guess to the extent that there may be some work done, we would be happy to be at the table. I would just bring your attention to line 25, which is current law, which I would just say is exactly what Mr. Norris was just saying, that if once you've received notice, if you remain, it is still criminal trespass. One possibility for a remedy to the things we've heard about today would be to incorporate that notice could come from law enforcement. So once they arrive on the scene, instead of having to come from the rightful occupant or owner, you could add to that list that law enforcement could provide the necessary notice to require someone to leave. But we join in and I spoke with Representative Vance this morning about some of the concerns about the collateral consequences, not, knock and talks, welfare checks, meter reading, trying to return someone's mislaid mail, their pet. I mean, the list, we could, if this was the old days and Senator Setzel were here, we could have a heyday with the ways that this could be detrimental. And I would also certainly defer to my learned colleagues from the state, but it seems to me that when someone is found sitting in my car, I'm going to ask the officer to charge attempted entering auto. If I find them in my home, I'm going to, even if they are not there for an unlawful purpose, I'm going to ask them to charge attempted burglary, which are much higher, more severe crimes than criminal trespass. Ladies and gentlemen, we have plenty of laws on the books to handle the scenarios that have been raised as concerns. I wonder if there's an education issue here around how best to construe the actions that have been described to you here today. We can actually charge them with much more than criminal trespass if it happens today.
What about, and I know you don't do this, but what about a squatter? And
You know, it's funny to me. I haven't looked at it. It's come up in these conversations today, particularly, but it does surprise me that wouldn't be an attempted burglary or at a complete burglary once there's some kind of taking inside. I mean, once you've converted, say, the utilities by using them, that's theft by conversion, and you've entered the home to do that. I don't understand why this is difficult to charge crimes for people who are squatting. I must just be
and I'll just kind of, and I think this probably will help with the conversation too, is that oftentimes, law enforcement shows up because a homeowner calls a squatter, and squatter's like, just shows a piece of paper and says, no, I'm a tenant here, it's a leaseholder. Then it just becomes an eviction case, and owner can't get to their property. And so
Right.
I see it, I think there are, again, many scenarios that we could go through, but just wanted to see what you thought about that. Do you have a question? Okay.
One
All
other
right.
piece
Thank you.
I do want to just also mention that there's been a thread of fear woven through. Mr. Norris mentioned an elderly person who might have some apprehension about confronting someone. We don't have an intent requirement in our simple assault statute. If you place a person in reasonable apprehension of fear, you don't have to have intended it to have completed that crime. So again, I just would ask you to consider the number of crimes that are available for each of the scenarios that have been mentioned today.
All right. Thank you. Yes. Chairman Leverett.
Thank you. Just your final comment. You said
Yes.
there was no intent element in which crime?
Simple assault.
Simple assault. Okay. So you don't have to intend to create the apprehension of fear if you do it. And
Reasonable, as long as it's reasonable.
Apprehension, then you've committed the crime.
Right.
Okay. Thank you. I just wanted.
Ben Lind.
Thank you, Madam Chair. I'm not going to take up a whole lot of time because Maisie Lynn, as she always does, covers the majority of the stuff that I would like to have covered. But a few things just from a legislative interpretation standpoint that I wanted to raise to this committee's attention. When we look at B1 through 3 as they exist right now, there are a lot of cases in both the Georgia Court of Appeals and the Supreme Court who get really muddled in their ways in doing analysis when a section that follows more specific sections makes those previous sections effectively a mere surplusage. And if entry or remaining without the consent of the owner that is it. That is all it is for taken for criminal trespass to be complete. Then I don't understand the purpose of B1, B2, and B3 because those are providing additional elements beyond what is already would be contained in the new B4. I won't belabor the point of the types of actions that could be criminalized under this statute. But before I was a prosecutor, the first job I had in law was actually doing 1983 defense for our law enforcement partners, one of the better jobs I've had. And so the first thing I thought about when I was looking at this bill is let me see if this is an issue where, because when I practiced as a prosecutor and a criminal defense attorney, I always saw notice being given by law enforcement when the owner, lawful occupant, or representative, I never saw the trespass notice being given by those individuals. It was always a communication to law enforcement who gave that to the individual at issue and told them to leave. So I was like, maybe they're violating people's constitutional rights. And so I started looking up 1983 liability and could not find a single case of where a person with apparent authority gave a trespass notice and a person was removed or arrested for criminal trespass where there was they found that it was a violation of clearly established law. The closest example I could find is when a deputy sheriff was being evicted and got the people who were coming to evict his property arrested for criminal trespass. But I don't think that's what we're talking about here. And so I want to echo what I think Maisie Lynn offered is a perfect suggestion in this case, where if all you have to do is just as we have C right now, which provides when a minor gives a parent authority to enter, like where the restrictions are on that, just add a C2 and saying for the purpose of this statute, notice from an owner, lawful occupant, or representative can be given either directly or through law enforcement. It meets the intent that I've heard of this bill today, while respecting that there's a whole lot of really important conduct that requires non-consensual entering onto property. We talked about knock and talks. Another one that the sheriffs I think will be interested in is service of process. If they want to go out and get search warrants to do either knock and talks for every single case, that sounds interesting to me. But I think that just have a C2 and say notice can be given through a law enforcement agent, just as it was for the primary. I think that covers all our bases and has us with a good bill that we could support. Thank you very much.
You have one
I'm
question.
sorry.
It's okay. Chairman Leverett.
Hey, thank you for your comments. Just so I can understand the existing statute, because I don't do a lot of criminal defense work. So it's basically currently there's 3 ways you can commit criminal trespass under B.
Right.
One is when you go on the land for an unlawful purpose. 2
Correct.
is if you go on the land after you've been told not to go on the land or into the car. And then 3 is you stay after you've been told to get out.
That's correct.
I guess. So we're adding one where just simply entering without consent is a violation.
That's my reading of the bill. Yes.
So it doesn't matter why you're going on. It doesn't matter if you've gotten any notice or been told anything. That would be the crime.
Or if the Constitution gives you that direct right to enter not without consent onto someone's property, as with canvassers, or I guess that would be the best example, where that's something that the Constitution doesn't provide the legislature the ability to regulate when canvassers enter your property.
So your contention would be those kinds of situations, enforcement of the statute in that case would be unconstitutional.
Yes.
So even though there's not an exception in here, you
Right.
think it would be drafted by.
And we always have problems because there are non-constitutional protections, door-to-door sales, which can be limited by the property owner. But having this as a statewide prohibition on that, allowing people to enter a property for the purposes of door-to-door sales, or some of the examples, other ones given today, more than just the constitutional infirmity, I think that as a matter of policy, you're kind of getting in some stuff that reliance on the discretion of law enforcement and prosecutors. While as a former prosecutor, I liked my discretion in that regard. It creates I have problems with that just being the code because we can't always say that the best intentions are going to prevail.
Right. Well, I would agree. While I trust prosecutors to use good discretion, I don't think that's a excuse for poor drafting. I appreciate your comments. Thank you. Thank you, ma'am.
Absolutely.
Thank you.
Thank you, Madam Chair. Thank you, members.
So, Representative Vance, I think we're going to keep this as a hearing only today, and if we can all get together and try to see if we can have some additional thoughts on this. If you want to get on the mic.
I think the young man that just spoke has a very valid argument about in Part C of adding some language. So if that is the desire of the committee, I have no problem with that. And like I said, all we're trying to do is make good law here.
I understand. And so if you can try to make that and add some language, be happy to entertain that later on.
Thank you, Madam Chairman. Thank you, committee.
Okay, with that, we have Representative Gollett's bill left, and I don't think he's back yet. We're going to go ahead and check on him, and so we'll go ahead and take a 5-minute break. Yeah. No problem. Okay, I just heard word that Representative Gullett is stuck presenting a bill in another committee, so we are going to adjourn for today. I've got another subcommittee on Wednesday at 1:30, so we'll go ahead and put that bill on the Wednesday calendar. Thank y'all for being here.